Hello, and welcome to our next panel. This panel is entitled New Day, New Tactics, The Plaintiffs Bar at Work. I'm Laura Lazarczyk, and I'll be moderating this session. I'll be joined by Bill Martucci, who is a partner at Shook Hardy & Bacon, Stef Zielezienski of Lehotsky Keller, and Stef Zielezienski, an executive vice president and CLO at the APCIA. So as we've heard earlier in the sessions today, we really need to punch back on the plaintiff's bar. And so what we're going to be focusing on in this session is how the plaintiff's bar is continually looking for new business models and to test new legal theories to expand liability and increase litigation. So we're going to explore some of these new trends, and we'll also discuss the ins and outs of mass arbitration and what litigation threats we can expect during the post-pandemic return to normal. And so with that, I'd like to turn my first question to Stef. Stef, welcome to the panel. Would you start us off by please providing some background about the mass arbitration trend that we've seen from the plaintiff's bar? And when it started, what are the key features, and what are the problems that are confronting defendants today?
Sure, and thank you, Laura. So mass arbitration is where a plaintiff's firm aggregates thousands, tens of thousands, even hundreds of thousands of claimants for individualized arbitration, although not for the purpose of arbitrating anything, but just for an arbitrage opportunity based on the terms of a business's arbitration agreement and the AAA or JAMS arbitration fee structure. In late 2019, the law firm Keller embarked on a novel strategy of signing up tens or hundreds of thousands of clients for individualized arbitration. They are a well-capitalized firm. They're a former litigation finance outfit. They are brilliant attorneys. They're a bunch of former Supreme Court clerks. And they developed their own proprietary software to enable them to engage new clients online and then communicate with those clients at scale. And their fundamental insight was to exploit the generosity of companies, especially companies that are operating on internet scale, who have millions of customers or gig economy workers on their platform. And those companies have arbitration agreements that pay the lion's share of arbitration fees, which are usually thousands of dollars, charged by either AAA or JAMS predominantly. And they've sought to take advantage of that generosity to inflict massive settlement pressure on companies who use arbitration. So let's say they amass 30,000 different claimants and the arbitration fees are $3,000 each. That's $90 million just in fees, to say nothing of the value, if any, of the underlying claims before you even start arbitrating anything. And so they started putting companies to the choice. Do you want to pay $90 million right now just to get this started and then incur the costs of arbitrating and potential adverse rulings? Or do you just want to settle with us? Now, if the company settles, then the plaintiff's firm has done relatively little work. They get money for nothing. And if the firm signed up 30,000 online users and then settles, given the scope of online platforms, they just go out and sign up another 30,000 clients and do it again. It's kind of like in football. We'll just keep running the same play until you stop us. And so if the target company doesn't settle, then they ratchet up the pressure some more. You didn't want to settle after the first 30,000? Well, here's 30,000 more. And very few companies are interested in paying $180 million in arbitration fees. Your CFO would have some questions then. And so like many clever ideas, this has spurred some copycats. Other plaintiffs' firms are now trying to execute the Keller-Lenkner playbook. Perhaps they're just copying, perhaps they're licensed or syndicated in some way, but the trend is definitely spreading.
Thank you, Stef. Maybe now we'll turn it over to Stef, and I'll ask Stef to talk a little bit about what is social inflation and why is it important, and you know how we connect that with the trend of mass arbitrations and the impact that both of those together will have for us and as businesses.
Thanks, Laura. I would define well, there are many definitions to social inflation, but in essence, social inflation is about changing attitudes of what is fair compensation for harm and how to pursue it. It's really a bit like hammering Jell-O, or a situation of knowing it when you see it. is in many ways both a cause and effect. The net result is spiraling litigation costs that are pitting both insurers and the individuals, businesses, and nonprofits they protect. Social inflation increases loss costs, and so I think it's directly related to topics like mass arbitration. And yet, it is also an end in itself by changing the overall environment in which all tort reformers operate. There are many drivers of social inflation, and many which candidly are not flattering to business and industry in general. Societal attitudes towards business, haves and have-nots, and institutions in general have all been a challenge for a long time. Time doesn't permit us to do a deep dive on the economic, sociological, or psychological underpinnings of these negative trends. Nonetheless, we can say that these changes in attitude are in no small measure due to the active encouragement of the plaintiffs' bar. After all, they want bigger, unmoored verdicts, and attitudes about what is right can help or hurt with that. So I'll reserve for the next question some of the examples of drivers of social inflation, Laura.
Thank you, Stef. So I'm going to turn to Bill next, just to put the third leg of the stool on the stage here, or the virtual stage. So, Bill, from a national employment litigation and policy perspective, what are the key considerations at this point in time with respect to what might be considered the COVID and post-COVID era?
Well, thanks so much, Laura. And really, the comments that I have really build on what Steve has said about mass arbitration and what Stef has said about social inflation. The reality is that there have been many, many lawsuits in this COVID era. Perhaps our public policy group believes there may be 12,000 or more lawsuits that have been filed, and they think that's a rather conservative number. And what's interesting within that is that the vast majority of the cases that have been filed thus far are in the employment area. And so what we're seeing, frankly, are great challenges, both with respect to accommodation issues, whether it's under the Americans with Disabilities Act or Title VII, as it impacts religious discrimination or health conditions with respect to vaccine mandates. So far, the cases have been very favorable for employers, but it's a great challenge, and there's a lot of nuances. And the other aspect, frankly, is wage and hour. We see a great deal of litigation in the wage and hour area, and it's been enhanced by virtue of COVID. So, for example, building on the idea of the generosity of employers, let's say that there is a wonderful bonus program that comes into play that is given based on attendance or based on productivity of a given group. It's tied to COVID. There's a fair amount of litigation now as to whether that impacts the regular rate. And if it impacts the regular rate, does it impact the rate that's to be calculated for overtime purposes? So truly, lots of litigation. Employment remains a major part of that. And I think, frankly, employers being ever thoughtful about their practices and ever more engaged in the interactive process permits the opportunity to diminish much of this litigation.
Thank you, Bill. So if I turn back to you, Steve, how do we pull these various strands together? What we're talking about here, the mass arbitrations, the potential for social inflation, pandemic-related employment litigation. What do you see how do you see those various aspects coming together and impacting business today?
Well, so I think there's one example, one recent case that maybe ties together all three of these themes. During the pandemic, there was a meteoric rise in food delivery, more people using DoorDash or Uber Eats or Postmates or Grubhub to order takeout from restaurants. And after the murder of George Floyd in the summer of 2020, some online platforms started offering discounts for Black-owned restaurants, waiving or reducing the delivery fees. And so one of the law firms that's litigating the challenge to Harvard's affirmative action requirement followed the Keller-Lenkner playbook and amassed somewhere in the neighborhood of 32,000 or so race discrimination claims against one platform. And this plaintiff's firm has been pushing these arbitration demands forward. Now, AAA has taken some steps to modify its fee structure for both employment claims and for consumer claims, and that reduces some of the cost and the pressure on businesses. But there's now pending litigation against AAA over the contractual obligation to pay those fees. And so that kind of ties together some of the mass arbitration, employment-related claims, social inflation that you see. And it's maybe one area to watch for developments in all of these areas.
Thank you, Bill. Excuse me. Sorry, Steve. I want to go back to you, Bill.
Sure.
You mentioned that you're seeing trends with respect to COVID litigation across the board related to employment-related matters. Looking ahead, what do you see as especially troublesome for employers?
For employers, the area of wage and hour continues to be a major focus. So it would seem that wage and hour would be way off the radar screen. But the truth is that almost any disgruntled employee that goes to see a plaintiff's lawyer wants to see if there's some built-in class action. And so wage and hour practices give rise to the greater likelihood that it's an across-the-board practice. So for employers to be ever more thoughtful about wage and hour practices, to perhaps conduct some mini audits and maybe even put together a COVID team. And the COVID team would be focused on wage and hour and would be focused on religious and disability accommodations, so that there's more of a opportunity to engage in the interactive process and to get ahead of some of these practices. But candidly, business has done a great job in terms of dealing with COVID-19, but we're going to see a lot of litigation. And frankly, it builds on what Steve said, and that is that it's so easy to engage the AAA on a lot of these claims and to build in sort of a mass expense of the arbitration process, and also a forum that in some respects has its own challenges because it can be remarkably expensive even on the discovery side. So perhaps a COVID team that focuses on anticipating issues and working through them with the operational management team could be remarkably helpful in this context.
Yeah, thank you, Bill. Hey, Stef, when I was listening to Bill, I thought about, if as we're going to get more employment litigation, potentially arbitrations coming out of COVID, how do you see social inflation in that context? What do you think it's doing in our litigation system?
As I said earlier, social inflation is both a cause and effect. So social inflation begets more social inflation. It breaks down norms of reasonableness, predictability, and compensation. In such an environment, social inflation and its drivers simply expand. We'll see more use of reptile theory, more damages, more attorney advertising, more litigation and medical financing. It's a feedback loop that many profit from and want it to continue and expand. Social inflation results in bigger and bigger verdicts in nuclear and routine matters. In 2019, there was a 300% increase in the frequency of verdicts of $20 million or more over the annual average that occurred during the period 2001 through 2010. We've now seen singular personal injury verdicts exceeding $1 billion many times, including the Roundup case out of California, $1 billion trucking negligence verdict in Florida, and $8 billion punitive damages personal injury verdict against Johnson & Johnson in Philadelphia. On the routine verdict front, the outcome is bad as well. For example, according to current award trends in personal injury data, median personal injury judgments have increased nearly 250% in 9 years, from $39,300 in 2010 to $95,000 in 2019. Awards ranged from $1 to $71 million in 2010, whereas they ranged from $1 to $740 billion in 2019. I'm sorry, $740 million. A more than 10 times increase in the upper bounds of awards in just 9 years. So this is, of course, all happens to coincide pretty well with the release of the Reptile Theory Bible in 2009. So you can expect more of that.
Yeah, those are really scary statistics that you shared with us, Steph. I'm going to turn back to you, Steve, and ask if you could provide us with some solutions for businesses to consider to this, the triad of these emerging trends.
Sure. Well, so I guess when it comes to mass arbitration, but I think it probably applies to a lot of what the plaintiffs bar does. It reminds me of one of Justice Scalia's favorite jokes. Two friends are out for a hike in the woods and a bear starts chasing them. One hiker says to the other, "How are we going to outrun this bear?" And the other hiker says, "I don't have to outrun the bear. I just have to outrun you." Point being, you don't have to be perfect. Just don't be as attractive of a target. Maybe there's somebody else who's slower and easier to maul out there. And so, the first order strategy when it comes to, I think, dealing with, any plaintiff's lawyer, like they're out there to make money, and they're trying to make as much money with as little work as possible. And so when it comes to something like, settlement on the mass arbitration strategy, they're trying to just aggregate as many claims as they can so that they can, get the maximum settlement. And you want to force them to disaggregate. And when it comes to amending arbitration agreements to sort of fix things prospectively, there might be a number of different things that could be done to try to break up the aggregation strategy of the mass arbitration firms, imposing gateways like mediation as a precondition before an arbitration demand, imposing different procedures for individuals who are represented by the same law firm, basically making it harder for them to use a mass arbitration firm, imposing certain procedures to make sure that there is really an actual live individual customer there, as opposed to, somebody who's just entered a bunch of email addresses online, trying to sort of fish for money. And then I think also being careful about what's known as a delegation clause in an arbitration agreement, where you're making a very careful decision about whether you want certain issues to go before an arbitrator or before a court. And if something is going before a court, then you've got more appellate rights and frankly, some pretty good precedent in the federal courts. And so that might ultimately be a better option. When it comes to old arbitration agreements, it's a harder strategy. That there aren't as many issues because you can't amend your arbitration agreement. You sort of have to play the hand you're dealt. AT&T had a pretty effective strategy when they dealt with some mass arbitrations about a decade ago of just saying, okay, we'll pay the fees. Let's go ahead and arbitrate these cases. And after they won the first several cases, the firm that was bringing these mass demands just went away and kind of gave up on the rest. It's obviously a lot different if you're dealing with a couple hundred cases as opposed to hundreds of thousands. It just requires a lot more money to pay up front to be able to get the arbitration started. But just remember, if they're thinking about settling the case, if you pay $90 million, let's say, to AAA, $0 of that going to the plaintiff's firm, and they still have to litigate or arbitrate all of these cases. And so you want to be thinking carefully about, what the incentive structures are as you try to figure out your settlement strategy to try to pick people off once you're into a mass arbitration situation.
Thanks, Steve. So, Bill, I'm going to go back to you and talk a little bit about potential class action litigation, specifically in the context of the ADA and the exceptions that may come into play in light of the mandatory vaccination policies that we're hearing from the federal government.
Thanks, Laura. I think just one comment sort of building up to that. I do think Steve's commentary about kind of what I might call refining or reconsidering some of the procedural aspects of arbitration is really a powerful set of comments. And I think in this context of mass arbitration, that's really meaningful. With respect to the class action aspects, the idea with respect to accommodations, whether it's in the area of religious exemptions, which is defined very broadly by the EEOC, or whether it's in the area of health conditions, the virtue of an interactive process and the virtue of having a policy that is somewhat flexible with respect to exemptions is that it makes it more difficult to establish that a one size fits all, that a class action is built in. And so I think truly with respect to good employment practices, good human resource practices, that interactive process can help a great deal. And with respect to wage and hour, where we have a class action process that's an opt-in process, I think there, again, being ever thoughtful about your practices and trying to differentiate them in different settings is really helpful to be able to defeat the class action threats. The other aspect here to keep in mind is that the more the employer can look ahead and really provide for policies that are flexible in different settings, then I think that's going to be of great help in terms of diminishing the built-in class action kind of possibilities. So there's lots of good hope out there and lots of good opportunities. And frankly, I think some of the greatest challenges are just to try to, as much as you want to have a one-size-fits-all, to try to build in some nuances to it that would help with respect to compliance with the law, and it would help with diminishing the opportunity to say there's great commonality and the class is otherwise built in.
Thank you, Bill. Just a quick question there. Do you think that the same would hold true with the religious accommodation?
I think it would. In other words, I think really there's, in all fairness, there's so much of this that's still fairly nuanced and new to us. In other words, the EEOC has defined religion very, very broadly as a basically sincerely held religious belief or sincerely held spiritual belief. But the aspect of looking at things carefully and working through it on an individualized basis, I think would take away the class action potential. And frankly, I think would serve well for good employment relations. It might avoid some of the social inflation kinds of considerations that Stef has set forth so well as well.
Yeah. Okay. Thank you. Thank you. I'm gonna switch back to Stef, talking about social inflation again, and ask, how is the trial bar reacting to all of this?
Like entrepreneurs always do. I kind of beat this concept like a dead horse, but they view the plaintiffs' bar views the U.S. litigation system as their own personal market, and it's a market in which they control the supply and the demand, and they're very inventive about creating new theories of liability. We heard a lot from Steve about mass arbitration as being a kind of unique twist on what we all view as a more efficient way to end cases, but they've turned it into a way to churn more fees. I just want to highlight a couple theories of liability and a couple aspects that we need to look out for. One is the connections between third-party litigation financing, medical financing and letters of protection, and so-called phantom damages. There's a lot of concern amongst businesses and insurers that a lot of those agreements are going on behind the scenes and aren't discoverable. And so I think one good reform that we could keep in mind is shining the spotlight and making those, behind backrooms kind of deals between medical groups, third-party investors, law firms, some without, out of the sight of the injured party, make those discoverable. And that would do a lot to reduce the social inflation in that area. In terms of theories of liability, I think what we need to keep an eye out for is, in terms of inventiveness, is, seeking to expand environmental liability, for example. So if you have new standards for reporting, those turn into expanding liability. Increasingly, we're seeing public nuisance put forward as, the tort of choice. Privacy litigation, cyber litigation, those are areas that are fertile ground for expanding theories of liability. that just will beget more social inflation.
Thank you, Steph. Yeah. It's spreading like wildfire, that's for sure. So, Steve, we talked a little bit about some solutions for businesses to consider. What do you think that what shouldn't businesses do when they're confronted with the arbitration demands?
Well, yeah, so I think when any business is confronted with a mass arbitration, or frankly any kind of novel, innovative strategy by the plaintiffs bar, there's this immediate tactical problem. What do we do to confront this strategy? So in case of mass arbitration, it's what do we do to confront this arbitration strategy? How do we adjust our arbitration agreements going forward? How do we deal with these thousands, tens of thousands of claims? But then the longer term strategic issue is, okay, what are they really trying to accomplish here? What are their ultimate goals? And in the case of mass arbitration, I think that goes to the position of arbitration as a way of managing or avoiding class action litigation risk. And so if companies just settle these mass arbitration demands as they come up, well, the plaintiffs bar will just keep taking that money. They'll keep making those settlements, and they'll use that to invest in more cases. They'll sort of they'll be able to self-finance essentially. If companies fight back in court, well, the mass arbitration lawyers have been trying to expose the apparent hypocrisy of companies forcing individuals into arbitration and then fighting the very arbitration scheme that the companies have chosen. And I know Judge Alsup out in the Northern District of California has been particularly gleeful in pointing this out. If companies decide to abandon arbitration rather than paying the AAA fees or settling, which I think some companies have reasonably chosen to do in their particular circumstances, well, that's just fine by the plaintiffs bar, because then they get to go back to doing what they've wanted to do all along, which is to pursue class actions. But they didn't have to amend the Federal Arbitration Act in Congress, and they didn't have to get a victory in the Supreme Court to erode what's been gained previously. And so for the company that then pays the fees and calls the bluff, a la AT&T, the next move of the plaintiffs' lawyers is to say, okay, well, we have these 10,000 claimants. How long is it supposed to take them to get relief? If the mantra is that arbitration is fast, fair, and efficient, how is it fast if it takes years or decades before some of our clients get relief? How is that fair and efficient if there's variation among claimants? And so they're using the sheer volume of these arbitration demands to essentially break the system. And I think that's similar to what you would see with social inflation as well. And unless there's some more resources put into it on the defense side to keep up with this sort of rising demand on the plaintiff side, it might be that that's where we end up, which I think would be a particularly bad outcome.
Yeah, no doubt. So we're coming up on the end of our time. So I thought I would move over to Bill and ask if you could kind of sum up if there are any key points or guidance that you would like to offer the business and corporate employers as we're coming up on the post-COVID era. What do you think would be helpful for them to help manage these potential litigation risk?
Well, as we come on what we all hope will be the post-COVID era, the reality is we're going to have a host of issues with respect to return to work and with respect to the abilities to accommodate those who wish to work remotely. And so I think truly for companies to be thoughtful about this, to kind of put together their post-COVID team. The Harvard Business Review recently had an article on return to work policies and all the approaches and concerns that come into play there. All the workforce issues in terms of attracting people to stay engaged in work. So the strategy development at the company level must take place both from the perspective of creating an environment that really is welcoming and inclusive and relatively flexible with respect to the working conditions. And at the same time, really articulating in a really clear fashion the ability to accommodate and to make the employer's location, whether it's remote or in person, an inviting place. The real sneaking tough issue, the sleeper issue, is wage and hour. And lots of issues in that context, both with respect to remote work, in the workplace, the 24/7 kind of world that we live in. And so to be ever thoughtful about that and ever more explicit about policies in that regard would go a long way to continuing to make the employer an attractive place.
Thank you very much, Bill. And thank you also to Steve and Stef. I think that we're out of time, but really appreciate your perspectives on this important trends and what employers and corporations can do to help combat them and also be ready for them, prepare to take them on as we move forward. So thank you all for your time today. Great panel. Appreciate your perspectives.